Andrew,
We're back, Gavin.
less than 10 days and we're back.
See you
Are
again.
you well, good man?
Yeah, good.
Excellent.
Very excited with the latest developments,
Correct.
and that's why we're here, Gavin.
Absolutely. The big one, RAF versus LPIIF and others. And very, very passionately, we were one of the others. You and I were in the trenches on this, and we did a lot of work on this and building up to this, and it's a great landmark judgment, which is going to have far-reaching implications. And I think our discussion today, we'll touch on that, and but more so on what the future holds. What does this hold for us? Let's just kick off by saying this is a great judgment.
I agree, and I think that although the industry expected, it's still a victory. I know that you put the hours into this in preparation, sitting with counsel, preparing, going through papers. So whilst it was expected, I think we have to emphasize that it's a victory, not only for the legal fraternity, because they've now got certainty, but also for the man in the street, the accident victim.
Absolutely.
He too has now certainty.
Absolutely.
So, absolutely. So, expected, but still a victory, and has to be celebrated.
Absolutely. Let's just for brevity, just touch on it. Literally from 2021, when the first board notice came out, but essentially from 2022, if we look at the two concurrent cases, Mautla and this one, literally the fund, the rogue leadership at the fund decided unilaterally they were going to publish this RAF 1 form. So the board notice and that which had empowered the new RAF 1, let's call it the new RAF 1, and then the old, the 2008 RAF 1, that form has been declared unlawful. So in the court AQO, it was declared unlawful, and the fund were given certain parameters that they had to act within. In other words, by September 2022, I think 2024, I think it was, you need to resubmit, etc. So we were on a big drive at that stage. We advised a lot of attorneys, resubmit with the correct claim form. So remember, all the way through all of this, that claim form was always declared unlawful. But because the appeal was pending, the fund just didn't accept that form, right? They wanted the new claim form. Yeah, we arrive at the judgment date, and what do? They ratify everything within the court AQO judgment, the matter which was before Judge Unterhalter and Co. So, interesting. Now they grant the relief, and they say, you now need to carry on. The fund gives the indulgence, as we've seen with subsequent communication from the RAF, that you can now run on your matter if you've lodged with the unlawful form, if you've lodged with the correct form, and they'll accept anything. So the best possible outcome, right? I think it's testimony to the current leadership at the fund that they're not going to run after frivolous litigation. I think this bodes very well for the future of the fund and the steps that they're taking. So while we know in the back of our minds, the fund they've been told that they need to promulgate a new RAF 1 if they want to change the parameters, we know that process is going to be very, very, I don't even know what the right word is. It's going to be watched so closely in everything that happens, from the promulgation right through to the public comment, input and all of that. So my feeling is it could take quite a while. Take quite a while for a new RAF form to come in. But the good news is what is in process as of where we sit here today. Passed from 2002, 6th of May, incidentally. 6th of May, which is tomorrow,
Correct.
4 years ago. Everything in that time period, and the relief sought that was granted by the court AQO that you now need, the fund now need to advertise, and they need to inform the general public. If you were turned away, if your claim was rejected, repudiated, whatever the case might be, you now have the opportunity to lodge. It's a mind blow, right?
100%. And Gavin, exactly that. It's actually vindicated the decision made in the court AQO. That court AQO set out the parameters, and now our appeal court says everything that the court AQO said was sound and is still applicable, other than the date to allow the resubmission, not relodgement, but the resubmission of all the documents to allow the Road Accident Fund to now process it. What's important is that as much as this judgment doesn't come as a surprise to us in the legal fraternity and the legal representatives on behalf of the claimants, I don't think it comes as a surprise to the Road Accident Fund either. No. So I don't know what's been happening in the background. I believe that they were expecting this, and they may have taken the precautions, and hence we will hear a lot more from the Road Accident Fund on the public forum and say, this is how we now are going to pay respect to the rule of law, and we are going to abide by this judgment, and this is what we require from you.
Correct.
But more so, Gavin, it's not only about resubmission of documents to allow them to register the claims, those that were not accepted as being compliant. What happens in the case where there's been a default judgment on an unregistered matter, or a trial hearing and an order was granted?
Correct.
So those are the aspects that they have to address.
Yeah. I think let's just quickly touch on what you said. Absolutely they were expecting this, right? This judgment dropped last week, long weekend, and we have a comprehensive piece of correspondence highlighting how the fund are going to act on this. They were absolutely preempting that this was going to happen. So that's 2 out of 3. We are awaiting the Discovery Health judgment,
Yes.
which should be dropping any day soon. Let's quickly unpack what now, the road forward, because both sides sit in a bit of a conundrum here. Let's look at it from the RAF side. The RAF needs to now advertise and say, please come back, resubmit your claims, right? As attorneys will remember, if we lodged a claim previously and they didn't recognize it in terms of that unlawful directive and the unlawful RF1 form, I'm going to emphasize those points, right, because there's a point to it. Then they gave you an ML number and they graciously returned your documents to you, right? In some cases, they were quite ingenious, and they actually sent them via courier so that they could prove they sent them back to you. So now I've got my documents back. So I've always maintained, if I send you my lodgement documents and you send them back to me, and you tell me it's an objection, I'm telling you I'm going to issue summons, because your objection is a thinly veiled repudiation. Because if I cure the objection, if you tell me submit the correct RAF1 form and submit an employer certificate, I have such a matter. If I do that, how are you going to process my claim if you've sent my documents back to me? So you've created an impossibility, so you've essentially repudiated my claim.
Correct.
Now they're sitting with all these ML numbers. I don't know what their database is in terms of how up to date it is and whether they've got a record of all of these claims. I see there's a lot of conjecture flowing around on social media and in the media about their potential exposure. But let's think about this. Any of those matters that are now being resubmitted are going to be done under the 2008 substantial compliance, which essentially doesn't entail all your RAF4, your medico legals or anything like that, which is exactly what we wanted.
Yes.
So you can get your claim lodged, let your 120 days run. So the 120-day settlement fallacy is going to fall away. I don't think that 120-day fallacy would ever have materialized. And I think even with their system in place, it never worked. I don't know, I haven't spoken to one attorney who actually got a settlement offer within 120 days after lodging, right?
Not that I'm aware of.
Exactly. So now we sit with the Road Accident Fund has got to deal with this deluge of lodgements. More importantly, let's go to the attorneys. What should the attorneys be doing? You and I know. What are attorneys going to do now? They're going to jump on the bandwagon. They're going to resubmit everything to the Road Accident Fund, which they say resubmit. Because when you resubmit your claim that's got an ML number, you're now going to get a claim and a link number. One could expect that.
Yes.
Okay. So now I resubmit my claim, and beautifully stated in the judgment, my previous lodgement date is applicable. So I can lodge and I can issue summons immediately. All right, essentially is what it would mean. Let's touch on now, what about default judgments? We know there's been many default judgments over the last few years. Now I sit with a default order in hand where the matter is registered at the fund on an ML number. I cannot on a court order resubmit to the Road Accident Fund lodgement documents. Okay? Creates a problem. They need to acknowledge the court order. So there's nothing, it's silent. The order, the judgment is silent as to what the court or what the Road Accident Fund needs to do in terms of the default judgments. So this is going to be a trial and error, and I'd be interested to see the first attorneys that you'd actually need to either draft correspondence to the fund and say, please acknowledge my order. Here's my default order, acknowledge it. By doing that, the fund is accepting all the heads of damages that have settled within that order. Now what happens if, let's take past medical expenses for an example. Let's say there's R1 million worth of past meds and the default court rubber stamped that and it went through. The fund have historically, on those default orders, if they were going to pay, would want to bill review. Now they come back and they say there's only $500,000 due to the client. What's going to happen?
So absolutely correct, Gavin. And what I foresee as well is that in that kind of situation, I believe that the powers that be and the intellectual minds that exist at the Road Accident Fund would have thought about this as well. How are we going to do it? Do we go to the attorney and say, listen, yes, there is the order. We are at a point where we now have to assess or reassess what's relating to this claim. Give us the opportunity, and then say, well, this is what we find on bill review with regard to past hospital and medical expenses. 500,000 doesn't relate to the accident, or there's no nexus to the injuries sustained in the accident, and try and come to some agreement. That's one aspect, and if the attorney is willing to reach some compromise, they must go back to the court or seek remedy the legal route or come to some agreement. But over and above that as well, I'm worried about the resources. Does the Road Accident Fund have the resources to deal with what you call a deluge of claims being resubmitted, and historically what has now happened over this period with regard to judgments and default judgments? Yeah. That's a concern. Do they have? It's not a question that I can answer. Right. I don't know. I'm hoping they have, because in the background you've got some accident victim waiting for his compensation.
Correct. I foresee this, Andrew. I see two camps here. You've got the camp of the new lodgements, everything that's now going forward, everybody resubmitting their claims. Note, I'm not saying relodging, resubmitting, because if it's been lodged previously, your claim's been lodged, right? Yes. Resubmitting the claims and trying to get the fund actively involved, right? So there's going to be a lot of pressure there. So let's say they've allocated manpower there. Now you've got on the back end everything that's accruing interest that's settled already in the way of orders, right, which are ML numbers, which they now need to fix, and they now need to get onto the payment system, potential bill reviews, everything that encompasses that. Somewhere, Afrikaans have got that saying that tussen die hand en die mond val die pap op die grond, right? So you're going to have this, their focus is going to have to be one of two. They do not have the manpower to deal equitably with both of those at the same time. Where is the shortfall going to come? And much like the system, this illegitimate system that's in place now, which has now been found defunct and unlawful, took a while to come in and to show fruit in favor of the fund. This, attorneys are going to have to be patient while they adapt back to the system as it was and fix the wrongs of the past. So I think it's going to be very telling and trying times going forward. I would urge attorneys to be patient.
Yes.
And I think what's important that attorneys must understand, go through your files. And I have so many attorneys saying, do I need to get the old, I've got the new RAF 1 form completed. Do I need to get the 2008 form now recompleted by the doctor? Please do not do that, right? Here's the rule of thumb. You've got until September this year, 2026, with the fund need to advertise, and everybody that was turned away to resubmit their claims. As an attorney, if you've had the old RAF 1 completed, you submit it. If you've had the new one completed, you submit it. Anything you have completed from today, request. If you request from today and you send to the doctor, send your old RAF 1 form. Attach the judgment to it, highlight the portion of the judgment, and the doctors will quickly toe the line. I've had a few doctors already that have advised, complete the old RAF 1 form. Let's say you've got a form that's in process that you haven't received and you're going to receive it back now. So, you know, your in-between ones, that lacuna period. It's very easy. What was declared unlawful? The RAF 1. Now, the RAF 1 and the statutory medical report are separate and divisible. Two separate things. And in terms of the Basuku judgment, what can you lodge with? You can lodge with a medical report of any nature or just the medical records. You don't even need the SMR. So, like we did when we were still in practice, we corrected it as such. We had all the new RAF 1 forms. Remember the court AQO said, you've got a new RAF 1 form. We just took that statutory medical report off the back. We attached it to the legitimate RAF 1 form, where we removed that medical report, and we submitted a hybrid form, right? I would recommend everybody just, if you're in that position, submit that hybrid form. do not go back and have the form recompleted. You're unnecessarily delaying your client's claim, and it takes the matter no further.
That's
If you have no RAF 1
yeah.
form completed, you've got the medical records, matters in fear of prescription. If you cannot find a doctor to complete it for you, lodge with your medical report. Attach the Basuku judgment to that.
That's the methodology that is the prudent approach, and that's what the attorneys should really do. There's also the situation where attorneys have held back on their lodgement, on their first lodgement of the claims, in anticipation of this judgment now. At least the attorneys will know moving forward, if their matters now are substantially compliant, according to the provisions of the law of what Section 17 and Section 24 say for compliant lodgement, you'll find that there will be an increased lodgement now. And I expect that the Road Accident Fund will accept those. And in light of the judgment, the claims will be registered and the matter will be processed accordingly. But I think there has to be patience on the part of the attorneys.
Correct.
I believe the approach is what you've just outlined now is the correct approach. And I think ultimately, if we give the chance to the Road Accident Fund, they will also, all these little nuts and bolts that need to be sorted will be sorted out. They're in the spotlight. The Road Accident Fund's in the spotlight right now. And they must not only do right, but must also be seen to be doing right.
Absolutely. It's a rule of law. It's right? So it's an unenviable position to be in. I would not want to be in the position on that board.
But absolutely. But Gavin, hats off to our judiciary.
Yes.
I mean, they applied their mind. This is a sound judgment, as you put it earlier. We all take heed of note of it, and we all now, can instill back the confidence in our judges and say, this is what we want. This is justice served.
Yeah. I think the judgment that they actually highlighted the points 1 to 5 or 6 of the court AQO, that they ratified those points as such, unchanged, save for the date, adapting the date to September this year, is testimony to the work that was put in initially, and that the correct judgment was sought and granted. I think it speaks to it. It speaks volumes to the research work that was done here, and that a great job was done. And obviously the LPIIF initiated this entire story. Mr. Thomas Harben, the director at the LPIIF, and I think they've been vindicated in their approach. And I think this is a great day for all accident victims. And just from the risk perspective, the risk that plaintiff attorneys were exposed to, because now you had to get all your medico legals in to lodge your claim. But the Act is very clear, the fund is very clear. You're not entitled to costs unless you don't issue summons against the Road Accident Fund. So had you got an offer within the 120 days and you've submitted all your medicos in pursuit and all the costs in pursuit of settling this claim, they wouldn't tender the cost of any of that. It had to come out of your attorney-client fee. So I think, and the risk is always there if you don't reach litis contestatia, that your client passes away and you've done 7 medico legals, you're not going to recover any of that. So the risk was diabolical for attorneys in the last couple of years. So I think the attorneys can breathe a lot easier now, can manage your client's damages claim a lot better, you can manage your risk a lot better, and I think at the end of the day, this is a sustainable system, provided the fund just cooperates and they just work with us and they keep the cost factor down. We don't want to litigate against it. We want to settle. I don't want the claim to run for 3 years.
Absolutely.
I want the claim to settle within a year.
Yes.
And I think if we can move towards that point, and I think this new board is progressive thinking enough, and hopefully the full-time elected board will be on the same trend. Time will tell.
Time will tell, and I think they are aware. I know out there in the media there's talk about all the money that the billions that they need to meet in terms of their obligation. But again, I think they're aware of it. I think that will be dealt with, that will be addressed. But constitutionally, from a constitutional point of view, I think we're in the right space now. We're moving in the right direction.
Correct.
So I'm very excited about it.
Absolutely. One last point I'd like to touch on is the fund, this deficit, this billions and billions of deficit. Just, I want to touch on that quickly. I get quite irritated because it's taken out of context when they say the fund is technically bankrupt. Okay. It's an actuarial deficit, right?
Yes.
Because if they take all the claims that are lodged there now based on the lodgement amount, you and I know if I don't have any medicos, I can't quantify my claim. So what do? I thumbsuck an amount that we're claiming from the fund to be amended once we've proven our damages.
Yes.
So just to get it lodged, you can't lodge with a zero amount on the claim
Yes.
form. So if they're taking all those amounts and they're saying if we had to pay everything today, the fund would be technically bankrupt, right? That's not the case. You've got to prove your damages. You've got to get to the point your client reaches MMI. So they need to say.
And more about, as well, your merits, Gavin.
Absolutely.
Not every claim
Is a
claimant's going to
concession.
get 100%.
Absolutely.
So there's going to be an apportionment.
Exactly
One
right.
claimant will get 50, another 20, another 80. So,
Exactly
yes.
right. So it's a very broad blanket statement, and I think people must stop fear mongering. It's the fund is a pay-as-you-go system. As we put fuel in the car and fuel's going up, those of you who haven't filled up, better do so. It's going up substantially. None to
Right.
the fund, unfortunately. But I think it's important that attorneys just understand, do the right things right to the benefit of your client, so as not to prejudice your client, and follow the rule within this judgment. And it's going to take you back right to where we were prior to all of this being implemented. In the interim, we're waiting. We'll see what the fund promulgates along the lines of substantial compliance in terms of the lodgements. I have no doubt they'll be exposed to legal challenges, knowing what problems presented themselves in the past. And but as always, we'll get together and we'll discuss if something arises like this. I look forward to chatting to you again once the next judgment comes out. And I think all our attorneys, our experts, prepare yourselves. I think the attorneys' practices are going to go through a bit of a shift now. In when the requirements are for medico legals, requirements are for lodgements, and I would advise all attorneys, if you need any input or any help, you're welcome to contact us here at Funda Medical. It's an all-encompassing service that can assist you in your practice, and please reach out.
Absolutely. Thank you, Gavin.
Thank you, Andrew. Look after yourself.
And you too. Thank you.
Thank you.